Welcome once again to Lehto's Law. Here's Steve Lehto.
I did a video not so long ago where I mentioned people at a party using a stun gun for entertainment. And I mentioned the idea that generally speaking in America, you cannot consent to an assault and battery. I cannot agree to let you attack me. And I said that the reasoning behind that is a public policy issue, and that is simply that if you were allowed to consent to somebody beating you up, anytime somebody beats somebody up, they go, oh, he asked me to do it. So there's that. But I had several people say, Steve, you know that mutual combat's still allowed in several states. And I said, well, I'd heard that, but I've never done much research on it. People kept saying, yeah, mutual combat is still a thing. It's still a thing. And it's one of those things, unfortunately, if you do some research on it, I don't think it's as common or as allowed as people think it might be. And so I did some research on this. And if you poke around on the internet and type in mutual combat America, you will find that there's 2 states that people say allow for mutual combat. But the interesting thing is that if you look for the statutes that say it's allowed, they're elusive, but you can find lots of websites claiming that the laws exist. And as a lawyer, I tend to look for the actual laws. So I've mentioned before, the blue books behind me are the Michigan law books. And so if I tell you that a law is on the books in Michigan, it's on those books, and I can point it out to you. So I tried to find what the statutes were in both Washington and Texas, because those are 2 states that people often say that mutual combat is allowed by law in both Washington and Texas. And so you can go down a rabbit hole on the internet looking into this stuff. But I did find the statutes that would appear to address it, and I don't think, again, that it's as widely acceptable legally as people want it to be. But here's the deal. In Texas, there's a statute, and it's section 22.06, consent as defense, the victim's effective consent or the actor's reasonable belief that the victim consented to the actor's conduct is a defense to prosecution if, 1, the conduct did not threaten or inflict serious bodily injury, or 2, the victim knew the conduct was a risk of his occupation, recognized medical treatment, or a scientific experiment conducted by recognized standards. So I mentioned in the video that obviously people are going to say, well, what about boxing? 2 guys are hitting each other. They've agreed to do it. They can't be arrested, can they? Well, that would be his occupation. That's a risk of an occupation. Also, I mentioned that technically speaking, a doctor operating on you and like removing a limb would be a form of battery, right? Well, recognized medical treatment, okay? And then the scientific experiment conducted by recognized standards. So here's the thing. It does say the conduct did not threaten or inflict serious bodily injury. So technically speaking, in Texas, you can consent to an assault so long as it does not threaten or inflict serious bodily injury. So mutual combat, knock yourself out, just not literally, because of the fact that you cannot inflict or threaten to inflict serious bodily injury. And the question is, what does that mean? And I don't know if there's case law interpreting that. There very well could be, but I suspect that's in the eye of the beholder and or the eye of the jury, okay? Because that's who's going to make the final decision on this. So if 2 guys agree to mutual combat in Texas and one of them seriously injures the other, they can still be prosecuted for assaultive conduct. And in case you're curious, assaultive conduct is defined in Texas as a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. Okay? And you've got to clarify that. In the old days, that was not obviously the case, so that's why they did that. Intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse. So notice that it defines assault both as the causing of bodily injury and the threat of bodily injury. And I mentioned before that some states will say that assault is the attempted or the threatened battery, and then battery is the actual offensive touching. So in Texas, like I said, mutual combat is allowable so long as you don't inflict serious bodily injury. And then, of course, the question becomes what constitutes serious bodily injury, because most people, I think, who would want to get involved in mutual combat would really like to seriously bodily injure the person that they're mutually combating with. Now, the other thing that I saw was a lot of people specified Washington. They said, no, Washington is like the Wild West. Washington allows mutual combat. And I looked this up because I'm curious to know what's on the books in Washington. And I actually went to the Washington code, which is online. You can search it, and search for the term mutual combat, and it came back with zero hits on mutual combat. But I did come back with a hit on dueling. And a lot of people who were talking about mutual combat on the internet, on the websites that I found, were talking about dueling. Because dueling, of course, is the idea that two people will agree to go out and face off in some manner. And in the old days, it could have been fatal. Also, quite a lot of times, it was not necessarily fatal, but it was just simply do you have the guts to show up and face the music, so to speak. So here's the thing. There is a section on dueling, and I saw several law websites that said this is the statute that addresses this. But it can't be for two reasons. One is it says any person subject to this code who fights or promotes or is concerned in or connives at fighting a duel, or who, having knowledge of a challenge sent or about to be sent, fails to report the fact promptly to the proper authority, shall be punished. And then it says, as a court-martial may direct. You go, court-martial? Yeah, because this is found in the section, Title 38, Militia and Military Affairs. So people who are in the militia, I assume that this state National Guard and so on, cannot duel. And so you might say, but Steve, if they say that you can't duel if you're in the military, doesn't that imply that you can if you're not? I think that's a bit of a stretch. But I did, as I stumbled down the rabbit hole, find the statute from Seattle. And keep in mind that this is a big country. And there's also a band called Big Country, at least there was. And they had a song called In a Big Country. But this is a big country. And so we have national laws, state laws, and there can be local laws. And in fact, some places might even have county laws. But we'll talk about this because this is Seattle. Seattle has a statute on fighting. And it says, it is unlawful for any person to intentionally fight with another person in a public place and thereby create a substantial risk of injury to a person who is not actively participating in the fight, or damage to the property of a person who's not actively participating in the fight. It then says, any prosecution under this, an affirmative defense can be made that the fight was duly licensed or authorized, i.e. a boxing match, or the person was acting in self-defense. So if someone attacks you, you can fight back. But does this allow mutual combat? Well, it does say it is unlawful for any person to intentionally fight with another in a public place and thereby create a substantial risk of injury to a person who's not actively participating in the fight. And some people might interpret that and say, well, that implies then that they can fight so long as they don't create a substantial risk of injury to another person. But the problem, of course, you have is that Washington has, like most states, laws on its books that say assault and battery are illegal. So this just appears to create an extra level of punishment that they can say if you got in a fight in public, not only can we charge you for the assault if we know who started it, but we can charge you for doing this where it can create the substantial risk of injury to somebody else or damage to the property. So what I would like to see, and I know a lot of people are going to be tempted to just chime into the comment section below and say, Steve, I heard about this. Washington allows it. Texas allows it. I found a website that says that. Yeah, I found those websites too. And if you were in Washington or you were in Texas and you met somebody who said, let us engage in a mutual affray. Let us. That's how people talk nowadays. Let's duel. Let's go outside and settle this like gentlemen. Let's go at it. Let's have a fight. Okay? Just for the fun of it. The two of us will go outside and fight, right? And let's suppose that you got arrested for that. And they said, we're going to charge you because the other guy ran away. We're going to charge you with assault and battery. And you go to court, and your fancy pants lawyers, and this, I'm telling you how the story plays out. You hire a fancy pants lawyer, costs a lot of money. Your fancy pants lawyer stands up and says, Your Honor, my client cannot be charged with assault and battery because he is involved in a mutual combat situation, which is made legal in this state by, and that's the point. You have to present a law that says that that's allowable. So if you can find that law in Washington, Texas, or any other state where there's a specific law on the books that says this is allowed, or you cannot be prosecuted because of this, and that would be in the form of a statute. Okay, so a website doesn't count, a YouTube video doesn't count, a listicle on yahoo.com doesn't count, okay? I want to see an actual statute that the judge could reach behind him, grab the law book, open it up, and go, oh, you're right, it's on the books. It's a law on the books. So that's what we're looking for, is an actual law that says you can do this. Now, interestingly enough, if you do the same dive I did into the internet, you will find discussions on this, places like Reddit and so on, where people say things like, well, it's not on the books, but everyone knows it's acceptable. That might be. But even then, you'd have case law where judges have said this is acceptable. Without case law and without a statute, you got nothing. And I've pointed this out before. I did a video a while back because there's this really, really dumb internet legend going around, and it's been going around for years, that in Michigan, a woman cannot get her hair cut without her husband's permission if she's married. It's not true. It never was true. And someone made that up because they thought it was funny. And I got someone who sent that to me last week. And I said, that's not true. And in fact, I did a video on this. And I think I named the video Woman Haircut Michigan or something like that, just so it would get high up on the Google results. People searched for it. And there is no such law. And you could say, Steve, how do you know there's no such law? I mean, you're trying to disprove a negative. No, it turns out those books behind me are antiquated. Everything is now on the internet and searchable. You can go to the Michigan compiled laws online and do a search for the word haircut or cut. And I actually did every possible search, and there is no such statute. And I've also searched the case law in Michigan. No such cases. Someone just made it up because it was funny, I guess. I don't know. But with respect to the mutual combat that you can get involved in both in Washington and Texas, according to websites, well, that's according to websites. And I'd really like to see the statutes that say that. So if you got one, fire away. But if you simply found the same websites I found, you can post that if you want, but I've already seen that. I'm looking for the statutes because I'm curious. Because from what I can tell, it's not as clear-cut as people seem to think that mutual combat is still a thing, at least not in these United States. Questions, comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
The search for happiness is one of the chief sources of unhappiness.